Stop, or I'll hold you in contempt. Unless she's lying to me, your office is disrespecting the Wayne County bench. Is that clear? Then why are you here? Who's the attorney of record? Your office is continuing to do this to the court docket with attorneys that are scheduled, that don't show, don't call, just ghost us. Answer my question. Clear? Make sure he brings a toothbrush when he comes for his show cause. Thank you. All right, appearances for People versus Littleton.
Morning, Honorable Seth Moore, on behalf of the people, 84724.
Good morning, Your Honor. Attorney Silva Cross and Attorney of Record James Case, hearing on behalf of Mr. Littleton. Mr. Littleton, can you please introduce your record?
All right, ladies, we ready to go?
Yes, Judge, the people are ready to go, and I have a complaining witness who flew in from out of this country to be here today.
All right, put her on the stand.
Your Honor, okay. Mr. Littleton, to return the competency at this time, the defense counsel is adamant that Mr. Littleton is no way understanding the nature or the object of the proceeding and cannot. He is not fully aware, Your Honor, when I try to ask him or explain to him that I'm his attorney. He doesn't.
Let me stop you. When did you talk to him and realize you had those problems?
Well, it's been a compounded conversation. So it was the first time that it was a little off. If Your Honor was, I'm not sure if Your Honor was the judge at that time.
Was not.
That I didn't think any.
Counsel, my question was a simple one. When did you know you had this problem?
So I'm telling you, it's a compounded issue, Your Honor. It wasn't just the first time; it was the second time also.
Denied. Denied. Twice I've asked you a direct question. You can't answer it. No, I asked you for a date. When did you know you had the problem? They flew somebody in from out of the country. If this was a problem you could have told them about a week ago, we could have avoided that. So we'll go ahead with the exam. You can do whatever you want. You can build whatever your record is. We're going to use the witnesses that are here today. I didn't ask for an argument, counsel. I just told you my decision.
Going to be completely. I think to be ready and what to be Mr. Wilson had no opportunity to review the discovery. I'm not the attorney of record.
Then why are you here? Who's the attorney of record?
And that is correct, Judge, as much as Ms.
So schedule a show cause for Attorney King for contempt of court. Would somebody like to explain to me why the attorney of record is not here for a scheduled exam?
Understanding when it's a different matter that he's planning to respond because I was going to come here anyway, and because Mr. Littleton was going to refer to competence.
No, he wasn't. No, he wasn't. You were going to ask for that.
The court, the statute requires that the court at least consider that the referral to competency at this point in time juncture. I understand that there has been a delay in the complaints from out of the country. However, the statute is very clear, and if Mr. Littleton cannot assist rationally not comprehend what is actually happening, actually he cannot move forward. And I think the court has an obligation to consider what.
Here's what I consider. Here's what I consider. Your office is continuing to do this to the court docket with attorneys that are scheduled, that don't show, don't call, just ghost us. We've got attorneys that show up the day of the exam having never spoken to their defendant repeatedly, day in, day out. Every Wednesday we have the same thing. Your office is disrespecting the Wayne County bench. Is that clear? We've been told we have to actually hold you people in contempt so that they can withhold the payment for the job that you're not doing. Would you like to say anything?
Judge, I just asked for an opportunity to make a fair record, if I may.
Go ahead.
So first of all, I would like to note that this is my first time actually working with Ms. Barrage. This is not, I believe, her choice. I believe she was sent here by Mr. King.
Oh, it sounds like they threw her to the wolves.
I just want to acknowledge that. I don't think that this is a problem for me.
No, she's just lucky enough to be the one I yell at. No.
Judge, I contacted Mr. King. I called NDS last week, contacted them specifically so that I could figure out ahead of the PCC who the defense attorney was. I found out that it was Mr. King. I contacted Mr. King. I got a hold of him that day. It was the day before the probable cause conference. I let him know that I was personally sending him the digital discoveries so that he could review it. I indicated that there may be some competency concerns, and I asked if he would let me know if he would be referring for competency. I also let him know that I spoke to the out of the country complaining witness, confirmed the next 4 to 6 Wednesdays her free in her schedule, and let him know that we would be flying her in, and told Mr. King that I would make any of those days work, but that if we scheduled an exam for her to be flown into the country, and Judge, this is very important, this happened at the airport, so flown into the airport that she was sexually assaulted in, that if that happened and if she came here, we were holding this exam. Because I was not going to have the victim come all the way back here, only to be told that there was an adjournment request or have him be referred for competency. I asked Mr. King that. I did feel at the time like he was dismissing me, but I also recognized it was pre-PCC. The PCC happened. I appeared early. I was not present when the actual date was set. It was set for 7 days out. We did everything that we could to get the victim here. I had the officer in charge meet her where her plane landed at the actual gate to get her from the gate through the airport. Again, she was sexually assaulted into her hotel to keep her calm because she's been extremely traumatized as a result of this. Prior to this, after all the arrangements were made, I started calling Mr. King 48 hours before the victim needed to leave to come here, just to confirm that he was not planning on asking for an adjournment for discovery, to confirm that he was not planning on referring the defendant for competency. He refused to call me back, refused to answer my text. I got a call from him this morning at 8:30. It was the first time he has spoken to me since pre-PCC last week. And that is when he told me that he had not spoken to his client, that other members of his team had fortunately stepped in to speak to his client for him, and that they were concerned about his competency, and that he wasn't sure if the defendant would be able to sit through with this hearing today.
This is totally unconscionable.
Which I told Mr. King that we would address the, because to be fair, Judge,
Mr. King better bring a toothbrush when he comes for the show cause. Please send that message. Clear? Counsel? Clear? Answer my question. Clear? Make sure he brings a toothbrush when he comes for his show cause. Thank you.
if I may, Judge, I recognize I have no actual power to object to a competency referral. And I recognize that. But the way that this was handled, it is one thing to inconvenience me, and I have a lot of respect for the Neighborhood Defender Services. There are several of them here at this courthouse that I have so much respect for.
Me too.
But how this was handled was completely inappropriate, and I told Mr. King that until there was an actual issue in court, we were here, we were ready to go, and I'm at a loss, Judge, because ethically as a prosecutor, I know that I cannot push to proceed when there is a genuine referral for competency. I don't want to compromise my ethics. But this is extremely difficult for the position that we are in. And the reason we're in this position is because of Mr. King.
If I may, Your Honor. Yeah.
Go ahead.
Well, thank you, prosecutor, for the procedural history. And I can't speak to the conversations of the prosecutor had with Mr. King directly. However, I will remind them, or just say, that at the times and moments that Mr. King was stating that he did not intend to refer to competency until after buying over, that those were true statements. And it wasn't until understanding the actual, and not to get into privileged communications and client confidential conversations that we've had, that even at this preliminary examination, even if it is probable cause, and even though he's told the prosecutor that we don't intend to refer to competency until later, it was clear that Mr. Littleton has an issue understanding the order, nature, and proceedings, as well as not being able to assist rationally in his defense. So it's not to say that Mr. King wasn't being honest or truthful, but
He was being lazy and unprofessional, counsel. He never spoke to the defendant.
Your Honor,
Unless she's lying to me, King told her he'd never met with Mr. Littleton. Other people from his office had.
I wasn't part of that conversation. I can't speak to them. I'm not
Then I'm going to take her at her word.
lying. I'm just saying that all the other times that she was speaking with Mr. King and he made the applications and the intention of holding this exam, that was his intention. It wasn't to be dismissive, he wasn't refusing to communicate, that he was figuring out.
Counsel, stop, 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 stop.
Right.
Stop or I'll hold you in contempt.
Just to make my record.
Keep talking, I'll hold you in contempt. I'm not going to let you make your argument because you don't know what you're talking about. You're not talking from firsthand knowledge. She is. Sit down. Counsel, don't test me. Sit down. You're done speaking today.
Done speaking today?
Yes, ma'am. Who flew in?
Judge, the complaining witness in this case, her name is Nora Alfamna, that's spelled Nora, last name AL dash.
All right, I'm going to want her in here in just a minute. Do the paperwork so we can send Mr. Littleton for his competency, which will be 6 months down the road before we hear anything. You guys can take Mr. Littleton back into lockup. Bring your complainant in. What's all being right?
Judge, do you want to come up?
Please,
All the way up?
just podium, yeah. Right here, ma'am. Right here. Did you tell her what happened?
I did not. I told her that there was an issue and he wanted to see her and that I would explain after.
So we're not going to have an exam today. I wanted to apologize to you personally for making you show up and put you through this and have nothing of substance happen. I also want to know exactly with documentation to counsel what it costs you to show up here today. Because if I find the attorney in contempt, I'm going to charge him for your costs. You understand that? All right. I just wanted you to hear it from me personally that I apologize on behalf of the system. I apologize to you because the system is not treating you well. Thank you, counsel.
Brilliant.
Ms. Moore, anything else?
Thank you. And again, I just want to acknowledge that I do not believe that Ms. Farage did anything. She was just sent.
I don't disagree. Thank you. Purdy. Mr. Mojica, your appearance for Ms. Purdy.
Michael Mohican on behalf of Hurricane P88245. Please state your full name for the record.
And Alicia Louise, are you?
Thank you. How about September 10th for an exam date?
It's September 10th, West Judge.
What time, Heather? Bond will be continued.
Yes.
All right, Ms. Purdy, you have a seat. We'll get you a notice. Counsel, are we ready on Black and Fields?
I'm ready on not Black and Fields for all of it.
I'm ready on that one. Your appearance for Mr. Meraldo.
Michael 8845. And Mr. Morrow. Hear me, can you please state your name, unmute yourself and state your name for the record? You go muted. What's your name?
Exam date, counsel? Same day?
Jacoby Maralda.
All right, Mr. Maralda, you know that, right?
Yes.
Yeah. You know we're gonna do live exams? We don't do Zoom exams?
Yes.
All right. Mr. Maralda, can you hear me all right?
Yes.
All right, we're gonna schedule your preliminary exam for September 10th, 2025. That's live. Understood?
Yes.
What time did we just do that one?
12.
12:30.
Yes.
Understood?
Yes.
Bond is continued. We will
Thank
mail
you.
you a notice.
Okay.
You understand that's live in person, my courtroom, right?
Yes.
Okay, travel safely.
All right, Mr. Maralda.
He's gone.
I'll go with Mr. Maralda.
We're ready on Fields and Black now?
Talk to his black attorney. Attorney right there. You have to feel it.
You want to do these at 1 o'clock? Yeah, come on up, Fields, Black. Appearances.
Morning, Your Honor. Staff, Michael P. 88245.
Morning, Your Honor. Giving praise on behalf of the Lands of Black people who are guys.
We're gonna set for exam. Good, because that's the only date I've got. How about 1 o'clock? All right. Bonds continued?
Yes.
Correct. All right. Gentlemen, we're gonna get notices for you two. And Mr. Black, you owe us money on some other stuff. Expired license from 24, speeding ticket from 2024. Looks like you owe us $651. Are you in a position to set up some kind of payment plan?
Yes, sir.
Yes?
Sir.
Take care of that downstairs before you leave. All right. Thank you, counsels. Guys, just have a seat. We'll get you a notice for that court date. Mr. Graziani, what'd you work out on those civil infractions?
No insurance bills on correction.
All right. That's going to stay. Everything else is going to go. All right. You are. Yeah. No agreed upon fines and costs or anything?
None, Judge.
All right. Let's do $250 on all. Miss Sarazin, am I saying that right? Can you pay $250 today? Tell me when. Congratulations. Good luck. All right. So you're starting on the 4th, which is Monday. 15th, enough time? You sure? Okay. All right. The original charges are dismissed.
Thank you, Judge.
You're welcome. Do you care which one I put it on? You want to put it on the civil infraction? Counsel, you pronounce it Eichinger?
Eichinger, yes. Good to see
All
you
right,
again,
and
Your Honor.
what are we going to do for Mr. Hernandez?
So we will just schedule an exam. I understand that there's a couple of dates you provided, Mr. Lucky. Those do not work for either of us. One between them. I was hoping to.
Okay, hold on. I got too much noise coming out of the jail.
Okay.
All right, so Heather gave you two some dates and you didn't like those dates? Did I follow
Well,
that?
Yeah, I could do September 3rd. The prosecutor can do September 9th, but those don't work for the other parties. So is there a chance we could do this at the end of August?
No. We can go into October maybe. I don't have any August dates after. I don't think I have any August dates. We don't have any August dates, do we? Heather's doing three things, guys. Give me Just a minute.
Yeah, no problem, Judge.
So do the name, the attorney. Yes. Okay.
We don't have any August exams, do we?
No, we don't have August exam dates, but, and since it's a special prosecutor,
No, it's left.
no, it's not, he's standing in for.
Oh.
For Corona. I think it is.
Yeah.
August 7th, in the afternoon, I don't think anybody.
August 27th, Mr. Lecky?
That should work.
Mr. Eichinger?
Yeah, I'm in Romulus actually on a bunch of other cases.
Those are probably all Zoom.
So those are exams on.
Okay.
starting at
All right, we
12:30.
can't do it then. I can't set an exam if you're on another judge's docket that day.
Okay. So we already said September 3rd is off. Jacob, there's no way to do that.
Wait, no, September 3rd works. I think. Oh, no, sorry. No, it does not. I apologize.
What day is that? Yeah, that's where I'm thinking right now. I'm going to hit up north for the conflicts. Are you still trying to do Wednesdays?
Sorry?
Are you still trying to do Wednesdays?
You have mediation?
Whatever day. Okay. All right. So what else you got?
Tuesday the 5th in the afternoon.
Yes. Next Tuesday afternoon?
The only problem is I'm lacking a lot of discovery and I need to have.
All right, I'm trying to be accommodating, but I'm almost done.
Yeah, I understand, Judge. It technically would work for the people. We're still working on that discovery. I think there's been an actual technical issue where I can't find it and I see it that's there, if that makes sense.
August 29th at 1. It's a Thursday.
August 29,
Works for us.
28th, 28th,
Works for us.
August 28th. Yes.
1 p.m.
1 p.m. Yes.
Okay.
And regarding discovery, I would like to submit a proposed discovery order because I have been missing most of the digital discovery for some time now. If the court is willing to entertain that.
I'll entertain the motion. I just want you to know I'm old enough that I've done a lot of exams with no digital discovery. So you're going to have to convince me that digital discovery is necessary for a probable cause hearing. But I'm more than willing to hear the argument.
Okay. Should I do that now, or would you like the motion?
Say again?
Would you like an oral motion now?
And
I have no idea. You can make an oral argument, but if counsel wants time to respond, then I'm going to give him time to respond. Doesn't matter to me one way or the other.
Understood.
I'm flexible.
Well, Your Honor, the digital discovery at issue here involves multiple statements with both my client as well as the complaining witnesses. So that would have their firsthand accounts in the event that they would sway from those accounts or maybe forget what they said, and therefore.
So it would be great for impeachment purposes at trial. This is not trial. This is probable cause hearing.
Correct, Your Honor, but I would also submit that sometimes it's beneficial to refresh their recollection if there's a fact that also.
I'm not in the beneficial business, counsel. I'm in the move the files along business. That's the task they've given me from the state court administrator's office. And these cases are from May 11, 2025.
Okay. So
just because it's nice doesn't mean it's required.
Okay. Well, hopefully I will have those videos before the 27th.
and Judge, I can briefly respond if I may.
I don't think there's a need.
Understood.
If there's the discovery's not here on the August 28th date, is that what we gave, August 28th?
August 28th.
If the discovery's not here, Mr. Eichner can make a motion to dismiss and we'll have the argument then.
Sounds good, Judge.
Fair enough, fellas?
Thank you. If I could address bond briefly, Your Honor.
All right. First, I think we should probably let the interpreter just fill your client in that was
Oh,
all
yes.
a bunch of conversation just about the date.
Thank you.
Mr. Interpreter, your name is pronounced how?
Cáceres.
Say again?
Cáceres.
Acetes? Raise your
No.
right hand for me.
Thank you, Your Honor.
Do you swear or affirm to accurately translate between Spanish and English, English and Spanish, so that we can all discuss this matter with Mr. Hernandez?
Here's where things get real. Notice how the court brings in the interpreter. This isn't just a procedural step. It ensures the defendant fully understands everything being said. Communication is crucial here. Any misstep could affect the fairness of the hearing. And watch how they start hashing out bond. This is where the stakes for freedom are first put on the table. The tension is subtle, but you can feel the courtroom holding its breath because every word matters when liberty is on the line. Ever wonder how much goes into setting a bond? It's not arbitrary. It's strategy, risk assessment, and legal nuance all rolled into one moment.
I do.
Would you let him know that the attorneys and I just had all kinds of conversation that just ended up with picking a date of August 28?
Ok, hemos tenido varias conversaciones con tu abogado y entonces finalmente hemos llegado a la conclusión de que la próxima audiencia va a ser el 28 de agosto.
All right, if we're going to talk about bond, let's agree what the bond is.
Vamos a hablar en cuanto a la fianza y van a discutir eso.
It looks like on each of these two files, the bond is $50,000 cash or surety.
Parece que en ambos casos la fianza es de $50,000 en efectivo o con una hipoteca.
You two attorney types agree that that is current bond?
Correct, Your Honor. Yes.
Los abogados están de acuerdo de que esa es la fianza que tienes por de pronto.
Yes, Judge.
Thank you. All right, go ahead, counsel. Let's make the argument.
Yes, Your Honor. As you know, my client's been in jail. He's been in jail for a few weeks now. He's indigent. I know he's facing serious allegations, but he's still presumed innocent. My understanding is he has no criminal history. I confirmed with his brother that he would live with his brother. I have an address for my client. He was working at the time. He would hope to get his job back. While one of these incidents was reported right away, the other one was about a 2-month delay. There are known parties involved here. There was heavy drinking. Obviously, I'm not going to argue the facts of the case, but I will say that because these are known parties, he's not a threat to the society.
This is the moment the courtroom changes. The judge stops being patient. This is no longer a warning. Every word now carries consequences. One wrong move, and freedom disappears.
Large, he knows to return to court, and therefore I'd ask that the court give him the opportunity to remain at liberty pending the outcome of these cases.
El señor abogado tuyo ha hecho un argumento en frente del juez de que cuando estos casos sucedieron habían estado pisteando bastante y por lo tanto, como no hay aparentemente víctimas que puedan presentarse y que tú no representas ningún peligro para la sociedad y que no tienes ningún registro delictivo, está pidiendo de que te dejen en libertad para que puedas regresar a la casa junto con tu hermano e ir a trabajar.
Mr. Eckinger, are you making a proposal for bond or you just want a reduction?
I am making a proposal of a personal bond, Your Honor.
Está haciendo
Thank you.
una solicitud para que te quiten la fianza, no solamente una reducción.
And Mr. Lucky, response from the people?
Yes, Judge. So I do understand that the complainant has no criminal history.
El fiscal entiende de que tú no tienes ningún antecedente criminal.
However, because of the severity of the offenses,
Sin embargo, debido a la seriedad de las ofensas,
one being a CSC in the 3rd degree of an incapacitated victim,
una que tiene que ver con conducta sexual criminal en el 3er grado en contra de una víctima,
and the other charge being a CSC in the 4th degree or a criminal sexual conduct with intent of sexual penetration.
Y la otra también en el 4º grado, una conducta sexual criminal donde intentó hacer la penetración.
Boom! This is where the courtroom drama peaks. The defense is pushing for a personal bond, highlighting the defendant's lack of criminal history, but the prosecution doesn't back down, especially with serious charges in play. Every argument here is about weighing public safety versus individual rights. Watch the judge carefully. Notice the subtle but firm signals of control. One wrong word, one hesitation, and it could tilt the balance. This is exactly why courtroom demeanor is critical. Here's a question for you. If you were the judge, how would you balance the defendant's history against the severity of these charges? Drop your thoughts while we keep watching.
Both of which the victim was incapacitated and the defendant frankly took advantage of her.
En ambos casos, las víctimas eran incapacitadas y tú trataste de tomar ventaja sobre ellas.
The people strongly oppose any change to bond at this moment.
Y la fiscalía se opone completamente a cualquier modificación de la fianza.
Thank you, gentlemen. Bond is changed to $5,000 personal bond, no contact with the complainant in both files. So that's each file is $5,000, no contact.
Ok, se reduce la fianza en ambos casos a $5,000. No debe de haber ningún contacto con las víctimas. I'm sorry, Your Honor, did you say 5,000 cash or 10%?
Personal bond, so that's a $5,000 promise
Personal
on
bond.
each file.
Ok, entonces te ha rebajado la fianza a $5,000, que es una fianza personal en ambos casos. Eso significa que no tienes que pagar nada de dinero para que te den la fianza, solamente la promesa de que vas a regresar a la próxima audiencia el 28 de agosto.
Mr. Hernandez, do you understand when I say no contact, I mean no contact at all?
Señor Hernández, ¿entiendes que cuando yo digo que no debes de ponerte en contacto con las víctimas, eso quiere decir ningún tipo de contacto? Enciende el micrófono y di sí o no.
Sí, lo prometo, yo no voy a estar en contacto con eso, con todo el corazón, lo voy a prometer.
Yes, I promise I will not be in contact with them.
All right. When I say no contact, I mean no phone calls, no letters, no social media.
Cuando yo digo no contacto, eso quiere decir no contacto personal, no llamadas telefónicas, ningún contacto vía las redes sociales o de ningún otro tipo como mensajes.
Sí, lo prometo con mi Dios, de que sí voy a cumplir.
Yes, I promise that in the name of my son and that I will do that.
All right. If she contacts you and wants to talk, she cannot change this order. Only myself or another judge.
Si ella te llama y quiere cambiar mi orden, ella no puede hacerlo. Solo yo puedo cambiar esa orden. Si ella te llama, tú cuelgas.
También lo prometo.
I also promise that.
All right, gentlemen, anything else?
No, thank you, Your Honor. If I could just briefly speak to my client in a breakout room.
Nada más, solamente tu abogado va a hablar contigo en privado.
All right.
Thank you
Heather
so
will
much.
put you, Mr. Hernandez, and the interpreter in the breakout room. Thank you, gentlemen.
Thank you, Judge.
Thank you, Your Honor. Ahí quédate. Ya nos van a pasar.
Shoulders. Counsel, your appearance.
John Bradford. Court rereading, 8-7. Yeah, on shoulders. Please state your name, sir. William Lorenzo, sir.
Good morning. Talk to me, counsel.
Judge, as the following discussions, we are accepting the offer of no operator's license. Asking for mercy.
Mercy.
Mercy for the fine.
You're in the judgment house, not the mercy house. Go ahead.
He can do it, Judge. He has agreed to shoulder. He was making $18.
3 children, he probably wants some jail time. Need a little break? How old are they?
3 months, 3 years, 7 years.
Yeah. Go ahead, Counsel.
What you can do with them? I did. Haven't signed the advice.
Okay. All right, Mr. Shoulders, did you discuss your rights and options with counsel? You understood all that? You understand the possible penalty for the no valid operator's license on person charge? Understanding all of that, are you pleading guilty today? Doing so freely and voluntarily? Did you drive a vehicle on July 7, 2025 while your license was suspended, revoked, or denied near 94 on Belleville Road? Satisfied, Mr. Graziani? So am I. I'll dismiss the original charge. What's the status of your license now? What do you have to do to get legal?
Have another hearing in the state of Michigan.
All right.
I had 3 hearings prior.
Are you getting anywhere?
No, sir.
You got to hire an attorney.
Judge, I've advised him to contact the Justice Center and
Yeah.
at least give him some resources.
Yeah.
Involved in an accident. So, that's.
Yeah, my experience has been that although, you know, it's a struggle, you got to come up with the money for the attorney. You're way ahead. You're way ahead. If you get the attorney that knows the system, right? You can't hire an attorney that doesn't go to those hearings all the time. You got to have somebody that knows the ins and outs.
Have any references?
That wouldn't be appropriate, but there are a lot of them around. He might be able to give you a name or two.
I shall.
All right. Okay.
Thank you so much.
You're welcome. You're working?
Yes, sir.
Where do you work?
Dumpster guy. John Bull Company.
How long?
3 years.
Okay. Anything else you want me to consider before I sentence you?
Yeah, I was just at work that day trying to make it. That was it.
Yeah. No, I get it. We don't have a good public transportation system.
Yes, sir.
No. I'll tell you what, I'll do fines and costs and I'll let you set up payments.
Yeah.
Or I'll let you do a number of work days. You pick the days, you schedule, and those days you got to be here before 8:30 in the morning. You go out, you work about a 6-hour day and you're done.
Sir.
So it'll be a number of days or money, or I could do a little bit of both. Total is $500. Go downstairs, they'll talk about options. You're welcome so much. Good luck with your license, sir. Deal. Appearances for deal.
Your Honor, my name is Shirley Singh. I'm rising to well in good standing of the University of Toledo College of Law. I'm requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of a.
Done.
Michael Barney for the defendant, Your Honor.
All right. Good morning. What are we doing?
We met with the prosecutor and my client's agreed to enter a plea under delayed sentence.
Okay. All right, Mr. Deal, you understand your rights and options? Understand the possible penalty? Understanding all of that, are you pleading guilty to the charge freely and voluntarily today? Can I mute them? Wayne County, do you have anybody else for us? Deputy, do you have prisoner Smith?
He's not our normal guy. Our normal guy is.
Yeah, I know. Okay. We're muted. We're okay then. I'm sorry. Go ahead.
Yeah, he was.
Yeah. Going to plead guilty. Yeah. You understand the possible penalty, you understand your rights and options, and you're pleading guilty freely and voluntarily, correct? Counsel, would you voir dire? Incident date on the file is March 8th.
March 8th, you were married on March 8th?
Yes.
And you and your wife were having a fight that day?
Yes.
And she had to leave the house or leave the house?
Yes.
Did she go in her truck? They didn't follow her out of the truck? She put her window down to talk some more? And you guys, so you got up on the running board of the truck so you could speak to her? And did there come a point where you flicked the ball cap with your finger? Like that's what you're on.
Counsel, satisfied with the factual basis?
That's gonna be a one more question.
Sure.
Where was the location of that?
$45,000 line, Fairfield.
In Maine County. Very satisfied, Your Honor.
Okay. I'll accept the plea. Are we inclined for an immediate sentencing or a pre-sentence investigation?
Immediate sentence.
Complainant here today?
Yes, it is the most.
Thank you. You okay with the immediate?
Sentence to you don't. Yeah, sure.
All right, what should I consider?
Your Honor, he was full-time before this. He's going through divorce right now, and I see a lot of these kind of back and forth incidents with the divorce. In my experience, it's a fairly minor incident. I see it all the time in divorce cases. He knows in the heat of the moment, he knows what's wrong. He was full-time employed until last.
Where at?
Power systems.
Louder.
Wolverine Power Systems. In Wolverine Power Systems.
Yeah, that like the ATVs, UTVs, like, what do they do? Ah, okay. How long were you there? Okay.
And he thinks someone about this incident, so he got terminated last week from that job. But
So currently you're not working at all? Okay.
they have a divorce mediation for September. So hopefully this is all by then. The only issue, and we can do that through, I'm not a divorce attorney right now, but any kind of, I know there's no contact, he agrees with.
This is a masterclass in judicial control. Melissa Pays thought she could sway the outcome, but the judge isn't just reading the law, he's sending a message. Probation is denied, court costs are imposed, and then the work program is introduced. Notice how the judge pivots to a life lesson. Alcohol abuse, repeated reckless driving. This isn't just a punishment, it's a warning to everyone in the room. The courtroom goes silent because the weight of responsibility is understood by all. That's power without yelling, control without theatrics. Listen closely. The judge's tone here isn't anger, it's authority. One slip behind the wheel could ruin lives. Could you handle hearing this directly if it were about you?
But if there needs to be some, obviously when they go to court, the worst case, that
Joe.
this one would count. But there's going to be times where he's going to need to go to the house to get his stuff out through the divorce case. I just want to, advise you of that, and you put that on the record here. If it ever comes back, he'll try to work it out with the divorce attorney as far as timing and things. So, but I just want to put that on.
All right, so the recommendation is that there'll be a no contact order as part of this probation. So how about if we change that to no contact unless it's through the divorce proceedings? Are we okay with that? Okay.
Thank you.
All right. I'll explain that card in a minute. Anything else? Anything you want to tell me? Don't feel that you have to. Is that a no? Okay. All right. I'll delay sentence for 12 months in keeping with the agreement with the prosecutor's office. I am going to order the batterer's counseling and the no contact, subject to what I just said. Let me catch up with my paperwork. 769.
In this intense courtroom moment, Melissa Pays stands before the judge hoping for probation. But the judge isn't convinced. After reviewing her criminal history and the seriousness of the charges, the judge delivers a cold decision. Probation is denied.
All right. In addition, I'm ordering $500 court costs. Go downstairs, talk about options on that. Kick that down the road until you get a job. I'm okay with that. And I'm ordering 4 days on the court work program. That card I just handed you, I noticed where you live, your address and maybe. That card is a friend of mine, full disclosure, who is always looking for people that will work. All right. It's crap work, right? It's wet, it's muddy, it's physical, but he probably starts $18, $20 an hour right now. So if you're just looking for something while you're looking for something, give him a call. He's in Monroe. That's why I gave you the card. Good luck, gentlemen. Thank you, counsel.
The courtroom goes silent. The judge doesn't need to shout because everyone understands what comes next. This isn't anger. This is control, and control is far more dangerous. A repeat drunk driving offender faces the judge in this tense courtroom hearing. The judge makes it clear that reckless decisions behind the wheel can destroy lives. Before delivering the sentence, the judge issues a powerful warning about alcohol abuse and responsibility, reminding the defendant that one mistake could cost someone their life.